Difference between Article 32 and 226. Now this both articles seems to be same, but they are not same. So what is the difference between this? Article 32, it is a fundamental right, while 226 is a constitutional right. Constitutional right means the right or the freedom that people have under constitution. Now those rights which are not in part 3 of the constitution, means in part 3 what we see? Fundamental rights. So those who are not fundamental rights, that are constitutional right, and those which are not in part 3 are constitutional right, and those are in part 3 that are fundamental right. So 32 is a fundamental right, 226 is a constitutional right. Article 32 can be suspended if an emergency has been declared by the President. Means in emergency period, Article 32 can be suspended, but 226 cannot be suspended even at the time of the emergency. Article 32 has a narrow scope as it is applicable only in the case of violation of fundamental right. Means as it is applicable in case of violation of fundamental right, that's why it has a narrow scope, Article 32. 226 has a broader scope as it is applicable not only in case of violation of fundamental right but also a legal right. Means in both cases 226 can be applicable in the violation of fundamental right or in a legal right. 32 empowers the Supreme Court to issue writ all over India, 32, while 226 empowers the High Court to issue a writ in its own local jurisdiction only. Means what is the jurisdiction? In 32, Supreme Court can issue writ all over India, but in 226 only the High Court and in its own local jurisdiction. Therefore jurisdiction of Supreme Court has broader territorial jurisdiction. Means here in territorial jurisdiction 32 is a broader, and in 226 narrower territorial jurisdiction as compared to Supreme Court. Article 32 deals with the power of the Supreme Court to issue writs. Which court? Supreme Court, and here only High Court in its local jurisdiction. Difference between Article 32 and 226.